I'm going to turn it over to Barbara Moskowitz, who many of you know. She is the Associate Director of the Caregiver Education and Support Program, which is part of the Dementia Care Collaborative. So I'll turn it over to Barbara, and then she'll introduce Steve. So thank you, everybody, for coming.
Thank you, Nori, and welcome, everyone. To our friends who we know very well, and I know I've been able to share hugs and handshakes with when we've met at Mass General, and to many new guests, I share a virtual elbow tap with you and send you our heartfelt greetings. So glad you've joined us tonight. This is a really challenging time for all of us, and I want you to know that our director, Susan Rowlett, and my colleagues, Nori Mazzone, Judy Willett, Chris White, Kelsey Anderson, and Gabrielle Rex are all, including me, we are all working tirelessly during this difficult time to continue to advance the mission of our program. We believe more than ever in our mission now and hope that you'll be able to enjoy continued programs. Our program, which many of you know, began in 2017, and we're part of the Dementia Caregiver Collaborative. No, that's not entirely. Yes, that is true. Okay. Which is in the Division of Palliative Care and Geriatric Medicine at Mass General. And most importantly, as many of you know, we exist at Mass General to educate and support patients, caregivers, clinicians, and everyone who's concerned about memory care. We offer care consultations to caregivers and patients in specific Mass General clinics, support groups, skills classes for caregivers, and also resiliency and healthy programs and programs about health. We're funded entirely by philanthropy, and I extend my heartfelt thanks to our supporters. And now, I just want to say my colleagues and I are thrilled that you're here tonight for this really important discussion, talk, seminar. And we'll be thrilled if you can extend future invitations to your friends, neighbors, family, anyone who might be interested in this seminar. It's open to everyone. And we are eager for everyone to be participating. So now, without further ado, especially since our speaker's mother is watching, and it's a thrill, I'm going to introduce Steven Cohen, who is a partner at Tavian and Russell, a leading elder law firm. Working on behalf of older adults and disabled clients, Steve is one of Greater Boston's most noted elder attorneys. For over 20 years, he's been dedicated to educating professionals and the community on the intricacies of elder law. Steve has been named a, quote, Massachusetts Super Attorney by Boston Magazine in the elder law category every year since 2006. And I'd like to say they've made a very wise choice because he is truly a super attorney. Steve received his undergraduate degree cum laude from Brandeis University and his law degree cum laude from Boston University School of Law. He's co-author of many articles and journals about the critical issues that we will be hearing about today, and he speaks regularly before senior and professional groups, including the Boston Tax Institute, Massachusetts Continuing Legal Education, and Harvard Medical School. Finally, and this is where I've learned so much from Steve over the years, he's a frequent guest speaker for healthcare professionals in hospitals and nursing homes, and is truly, what he's masterful at doing, as I know you will hear, is taking complex law and regulation and helping us learn it and digest it in ways that are meaningful to all of us. Steve is married with 2 daughters. He loves to hike in the White Mountains with his dog, bike to work, even on rainy days in downtown Boston, and dig around in his garden. And now it's my enormous pleasure to welcome Steven Cohen. Thank you, Steve.
Barbara, thank you very much. I want to thank my mother for writing that introduction. I guess just to start with, I have to acknowledge that, these are really strange times. And it's just, on the one hand, it's sort of bizarre that I'm sitting here in my house, sitting at my desk and talking to all of you. On the other hand, it's pretty cool that we can all be together, even though it's virtual. And I want to thank Mass General for giving us this opportunity, and the Caregiver Support Group, which is a great program, and Barbara and Nori for helping coordinate this and pulling this together. I feel fortunate to be here and be able to share this information with you. Tonight, I'm going to be discussing the basic steps you can take with your estate plan for yourself and your family to give yourself peace of mind, hopefully, that you're prepared and empowered in making sure that you achieve your goals. This is a time when we are all feeling anxious, whether that's because we're not able to get toilet paper in the store, or someone's not, standing 3 feet away from us and not 6 feet, or related to tonight, I've heard someone talk about a healthcare proxy. I don't even know what a healthcare proxy is. What do I do? So hopefully through the course of this evening, you'll be getting information that is going to help you understand how you should be thinking about your estate plan and developing a roadmap of what you need to get done, if anything. But that's the goal. So Nori, if you can switch the slides and get us on the shared screen. Great. So can we switch that to the next? So, to start with, we thought given how anxious everyone's feeling, that we should have a slide that was a peaceful, kind of tranquil image. And with this idea that, you might be feeling worried about this, there may be something going on, but don't panic. There are answers, and there are resources. I mean, how fortunate are we even that we can all be together? We've got all of the support provided through Mass General, and there are lots of professionals who can give you advice and answer your questions regarding your plan, and help you figure out how to be prepared. And if you see me raising my finger, that's my signal to Nori to change the slides. So, the first steps and what you should be thinking about in getting organized for yourselves, for all of us, is to gather the basic information that would be helpful if someone needs to step in and manage things on your behalf. So that would include gathering your financial information, identifying accounts, your existing legal documents, it may be collecting passwords for online accounts or social media, and having that all organized together in one place in the house, and then communicating that to the people who will help support you in the event of you're becoming sick, or to the extent, for all the caregivers, helping the people you're taking care of pull together that information and gather those documents. Next, you want to think about, assembling your team. We've listed out family support, financial planner, attorney, accountant, life care manager. Not everyone needs all of these members of a team, but these are the different kinds of people you should be thinking about. So, family support, hopefully you've identified, who you would want to make decisions for you. Or if you're a caregiver, you know what role you're supposed to be taking on. So this, in addition to identifying people, this requires good communication. You need to be asking questions. Do you have a power of attorney, mom? Or, asking someone, would they be willing to serve as your healthcare proxy? Some people may need a financial planner. If your assets are more complicated, we're going to be talking about documents, so it may be necessary to have an attorney help support you. If you have a complex tax situation, you might be working with an accountant. And many people might find it helpful to work with a care manager. Not everyone's as familiar with care management as they might be with some of these other roles, but care managers are typically social workers. And I know for myself as an elder law attorney, I frequently work with care managers who help people address the myriad of issues that arise as you age, whether that is, where should I live? Is it safe for me to stay at home? Should I be in an assisted living, some other kind of setting? Vetting different places, helping organize home care. So they can be a terrific resource, and it's something you may want to avail yourself of. So next I want to talk a little bit, these are some of the documents and subjects we'll be considering, a legal toolkit, if you will. So some of the documents that you should be making yourself familiar with are durable power of attorney, healthcare proxy, medical directives, what's a guardianship, wills, probate, trusts, and care committee agreement. And these are different documents that, again, not everyone may need all of these things, or the subject matter may not be relevant, but these are things that people often hear about, and I think it's helpful to at least understand what they mean. So one of the most important things in an estate plan for everyone, whether you're 28 or 88, is having documents in place where you are appointing decision makers in the event you become incapacitated. And in addition, you can be giving directives to these decision makers so that they understand what your wishes are and how you would like decisions to be made on your behalf should you lose capacity and no longer be able to manage for yourself. So to start with, I wanted to talk about healthcare proxy, and this is one, of the most important documents for all of us. And so a healthcare proxy, just to start with, is a legal document where you're naming an agent to make medical decisions on your behalf. So everyone, as long as you have the requisite capacity or have a sufficient cognition, we all make decisions for ourselves. And so that when you're facing some medical decision and a doctor knows what you want to do, they would be asking you directly. But the idea of a proxy is recognizing that a situation may arise, whether through a cognitive decline or perhaps temporary during surgery, that you're not able to make a decision for yourself. So the proxy allows you to choose another person who will make those decisions for you. So the first thing to just think about is, well, how do I choose someone? Who would be an appropriate person? When I think about this, the first thing is that it's someone that you trust and that's someone who you believe will follow your wishes and make appropriate decisions on your behalf that honor your wishes regarding medical decisions. In addition, I think it's important to consider, would this person be able to be an advocate for me? So often when people think about healthcare proxies, their minds immediately go to end-of-life decisions. Who's gonna, pull the plug, so to speak. But that doesn't actually happen that often, where it's the drama of removing life support and the healthcare proxy making that kind of decision. It's usually, more often more mundane. This is someone who could be overseeing and coordinating your care. They could be taking you to doctor's visits, speaking with physicians, healthcare institutions, pharmacies, and being in charge of your whole healthcare life. And our healthcare system has become so complex and bureaucratic that you really need someone who is going to be able to speak up and advocate for you and make sure that not just that your wishes are met, but that you're getting appropriate care and asking the right questions. So not everyone is able to manage that. So if you're choosing amongst people, that's something to consider as well. In addition, proximity is something to keep in mind. So if you have 2 children and everything else is equal in terms of their abilities, but one is in California and one lives around Boston with you, I think that proximity is a factor that should be considered, because the person who would be actually showing up in the emergency room or going with you to a doctor's visit may be more appropriate as the person who could serve as your agent. The proxy doesn't become effective until your physician in writing makes a determination that you no longer have the cognitive ability to make decisions on your own. And that's referred to as invoking an invocation of the healthcare proxy. And until that's done, as I said, there's an assumption that we all make decisions for ourselves. It's very important, really critical, that you are communicating with the principal and the agent. So if you've been appointed, if someone tells you that you're going to serve as healthcare proxy, or has asked you, I should say, whether you would be willing to serve, that should be a way of opening up the conversation about what this person's wishes are. Because if you have a healthcare proxy, but the person you're appointing has no idea what you want, then, how much have you really accomplished? The idea of this is to have your wishes respected and enforced. So it's important, the person you're appointing needs to know what those wishes are, both so they can make the right decisions and feel comfortable that they're doing things appropriately.
Steve, can I interject with a question, please?
Sure, please do.
When you speak of, I have 2 children, one in California and one local, which is understandable that there's a reason, given proximity, that one might choose the local child. However, if they are equally important to me, is there a mechanism on a healthcare proxy for having one be the agent and another be an alternate? And does that serve a purpose so that I can engage both of my family members or 2 friends equally?
Yeah, that's a great question, Barbara. And so for all of these documents that we're talking about, when I'm discussing naming someone to be in charge, to be your decision maker, you always, if possible, want to have someone next in line, a successor, an alternate, because who knows in life, the person you're naming when you need them may not be available. whether they're out of the country or they're sick, or perhaps they're not, they themselves might lose the cognitive ability to manage things. So we always recommend having a backup. And when you're thinking about that, if you can and you have the choice, you know, if you're naming your spouse as your agent and you're 75, and then you're naming your older sister who's 85 as your alternate, that may not be the best planning. So ideally, the alternate should be somewhat younger, especially for older clients, so that the idea being you're increasing the likelihood that you'll have someone who can actually serve. The other thing to keep in mind that Barbara's question reminded me is, in Massachusetts, you can only name one person at a time as your healthcare proxy. So, you know, often if you have, especially if a parent is naming children, you know, no one wants to exclude anyone from this process, but you really can only name one person, and if under the law, and if you do otherwise, you're going to create some unnecessary complexity and possible confusion. And what I would say to that is, you know, when I'm talking to my clients, I think it's helpful if a parent explains to children that, you know, why they're naming one person, but the idea would be, where possible, even though one child is the actual agent, that they are all communicating together and working together. Ideally, if it's a family that functions in that way, and not all do, but if they can, that they're communicating and they make decisions together, and the agent is in effect the spokesperson to communicate the decision. You can always revoke your healthcare proxy. So even though you're naming someone, if you change your mind and they're no longer appropriate as a decision maker, you can change your mind later and name someone else. And, you know, just lastly, again, I think I already said this, but you need to communicate with this person. The starting point always, when you're going to sign a document that names someone, is to ask them, would they be willing to serve? And that has two purposes behind it. One, you don't want to name someone who doesn't want to serve in that role, and they don't have to serve. So you want to make sure that they're willing. And the other purpose in doing that is so that the person knows they've been named. I've had cases where, you know, children had no idea that the parents had done any planning and that they had any roles. And if people don't know that they're in the roles and even have copies of these documents, then you might have accomplished nothing, even though you had the documents signed. I also recommend giving a copy to your physician, so it's in your medical record, and communicating between the healthcare proxy and the power of attorney as well. Lastly, I often create a separate HIPAA medical release as a separate document that allows perhaps, it could just be the agent, but it could be additional people who have the ability to communicate with healthcare professionals, even though they're not the actual decision makers. I actually want to just, if we can skip to the next slide and come back to this in a second, Nori. Thank you. So I wanted to talk just briefly about medical directives living will, which is, it's a similar subject to the healthcare proxy. So the healthcare proxy, as I just explained, is a document where you're naming an agent, you're naming a person to make decisions for you. A living will or medical directive is a written statement about what your wishes would be in terms of a range of medical situations, and that might be end of life, it may be others. The healthcare proxy is, you know, well supported in Massachusetts, and there's a healthcare proxy statute that outlines exactly how that functions. A living will is not the same. It's not legally binding. It serves more as evidence of what someone's wishes are. You can have a separate living will document if you like, and there are many samples of these online. There's something you may have heard of, the 5 wishes, often people use. Many versions of this. You also can just write your own. In my office, I like to include the living will language as part of the healthcare proxy document itself. So, and the idea that I generally try to get across is a very broad strokes of what someone's wishes are. You know, whether that be if I don't want to be kept alive, if I have no cognitive recognition of anyone, if there's no quality of life, or whatever that is. We capture that in some general language that reflects the client's wishes regarding how they want decisions made.
Steve,
Barbara?
can I make a quick comment? Thank you. I know that when I initially learned about medical directives, I felt overwhelmed, and many still do, about how do I really know how to write the language, or what is it that I want or don't want. And the reality is that the most important way that we can create a medical directive is to talk about what we value in life, what matters to me if I'm ill. Please know that we don't need to be knowledgeable about every kind of medical device or about ventilators. We are hearing a lot about ventilators these days. It's more of an effort to capture your values. And finally, I'll say, as Steve mentioned, the 5 wishes, there are a number of documents that if you email us, I'll be happy to send you the links to, and they will help you organize your thoughts about this issue. Thank you, Steve.
Thanks, Barbara. Yeah, and I think in the same way, you know, the form in my office, the form we use, it's sort of a starting point, and people often tailor this. You know, some people have stronger feelings about dementia and want to make sure that that's addressed, or dialysis, or a ventilator. So whatever that is, you know, you can really tailor the document so it reflects your values. The last thing I want to just say in this slide, although a living will is very important, or advance directive in your proxy, it doesn't replace having the conversation with your agent, because that is always going to be more nuanced. And, you know, I remember reading something, it may have been a book by, or an article by Atul Gawande, and he gave the example of a guy who he knew, a patient of his, in talking about quality of life. He said, you know, as long as I can watch a football game and enjoy chocolate ice cream, that's decent life, and I want to stay alive. If I can understand that and appreciate that, that's good for me. And that's not something you would have in a living will, but that might have been helpful to his agent to really understand, you know, how do I make decisions as you're navigating difficult choices that may be presented as someone's health changes over time, or they're presented with tough choices relating to care. So, you know, again, we all need to talk about this. One other thing, actually, as I'm mentioning that, I don't remember exactly what the link's called, but there's a website, the Conversation Project, which is a great place also to check out online. It can help you create a framework and give you some direction about how to go about having these conversations and initiating them, so that we all end up with a better chance of having our wishes respected. So that's something I would recommend to take a look at. Can we go back to the power of attorney slide, Nori? So we talked about medical decisions and wishes with the healthcare proxy and advance directives. The other side of this coin is a document called a durable power of attorney. And it's similar in that you're naming a person to be your decision maker, but where the healthcare proxy is a document where you're naming a medical decision maker, your durable power of attorney is a document where you're naming someone who would be making financial and legal decisions for you. Now, the most important thing when you're signing one of these is that it be durable. And that what that word means is that it remains effective regardless of incapacity, which is in some ways is kind of odd, because why else would you want to have a power of attorney other than, for the most part, if you become incapacitated? But the funny thing is, if it doesn't say specifically in the document that it's durable and that it remains effective regardless of incapacity, it actually won't work when you need it most. So that's really a very, very important piece of the document. Power of attorney only is valid while you're alive. When you die, it's over. Your power stops. Now, in thinking about who you might want to choose, it's really a different skill set than you would think about for a healthcare proxy. In choosing someone who's going to manage your finances, similarly, I guess to start with, you also want to trust that person, because you're giving them a great deal of power and control over your assets. So it's something to really think hard about. Is this someone I'm comfortable giving access to all of my financial, all my financial assets, all my financial information? And if you have even a little bit of doubt, then I would not have that person serve. Secondly, I would take a look, when you're thinking about who to name, think about how they're managing their own financial affairs. If the person you're thinking about naming has gone through 5 bankruptcies and has never balanced their checkbook and is always asking you for money, not the best person to name as your durable power of attorney. You want someone who, I would say in general, that their own financial life looks pretty good to you, that they're secure, that they're organized, they can follow through and get things done, and they have, I guess, just common sense. And what I mean by that is, if they've never managed money and suddenly they have to manage a brokerage account, that they might get help. Or if they've never dealt with filing taxes, they would talk to an accountant or perhaps a lawyer. So that kind of common sense. You can, unlike the healthcare proxy, you can have multiple agents. Again, you always want to have a successor, but with a power of attorney, excuse me, you could name more than one person to serve at a time. If you are going to do that, I would suggest, you can choose whether they have to make decisions together or can act unilaterally. It can become very burdensome if they have to make their decisions together. So I generally recommend that they be allowed to make decisions and sign things separately. If you name multiple people and they disagree, you can have problems. So I have a slight bias to naming one person at a time, but if everyone's getting along, it can be fine to name multiple people. Barbara. You're muted, Barbara.
Steve, I'm aware that our time is flying and we're only at the beginning, but I do want to ask just one question for now, because this is something you've taught me. Can you define the difference between a springing power of attorney and a durable? And do you recommend one or the other? And then we could slide into the rest of the program.
Sure. So I would say I think the difference between an immediate and a springing power of attorney. So immediate, it's
Right.
effective today, the first day you're signing it. That doesn't mean the person should be running out and writing checks on your behalf, but you're saying today they are empowered to act. A springing power of attorney only becomes effective, it only springs into effect when a contingency occurs, typically when a doctor in writing has determined that you lack capacity. My preference is to use an immediate power of attorney, and that although springing sounds good, it makes it's more difficult to use and more complicated, because now you've got to satisfy a bank or other financial institution that the letter that was signed by a doctor is still effective and that you are indeed incapacitated. So if you trust the person to only act when it's appropriate, then I recommend that you use an immediate power of attorney.
Okay.
I think, let's go to the next slide. So I think guardianship and conservatorship, just briefly, if you don't have a power of attorney in healthcare proxy, and you have already lost the capacity to make decisions, so you no longer have enough of an understanding to even sign these documents, the only way that someone can help you and make decisions on your behalf is to go to court and ask a judge to appoint you as guardian, which is decisions over your person, medical decisions, or conservator, which are decisions over finances. So it is something to be avoided, and that's one of the important reasons to have these documents. It allows you to avoid having to go to court. Sometimes it's necessary, regardless, and especially if there is mischief where someone is taking advantage of its elder abuse. Regardless of having documents in place, you may need to go to court for there to be an adjudicated decision as to who is ultimately in charge. But for the most part, we try to avoid this by having these documents in place. Can I have the next slide? So next, in just talking about the basics of your estate plan, I want to discuss wills and trusts. And these are documents that can both help manage assets while you're alive and indicate how assets pass when someone dies. Can I have the next slide, please? So your will. Most people have heard of wills and are familiar with that. A will indicates how you want your property to be distributed when you die. If you don't have a will, your property is going to pass by what's called the intestacy statute. So the Commonwealth of Massachusetts has taken the liberty of, in effect, writing a will for all of us. So if you don't do it yourself, state law decides how the assets pass, depending on, and it's basically depends on whether you're married or whether you have children. It will indicate, the law says, how the assets will go. But it can be a very important reason why you want to have a will, because your wishes might be different than what the intestacy statute says. Your will only governs the assets that are in your name alone when you die. So there are other ways that assets are held. You might own your house jointly with someone else, or you might have a life insurance policy that has named beneficiaries. That joint asset, the house or the life insurance, will pass in ways different than the will, depending on who the other joint owner is. So I might own my house jointly with Barbara, but my will says I'm leaving everything to my friend Nori. Barbara will get the house because she is on the deed as a joint owner. So it's important, and this is true in writing wills and trusts, you want to coordinate how you're writing that document with how you're actually holding your assets, because otherwise you can have an unfortunate scenario where, if you haven't thought it through, where your will says one thing, but your assets say something different, and that may cause friction, or it might result in the assets not passing in the way you intended. Your will also allows you to name a personal representative. That's the term we use now for what used to be called an executor. That person's in charge of your estate when you die. You want that person to be responsible, as I described, the power of attorney. You also can name a guardian for minor children or for a disabled spouse or adult disabled children. So that can be another important way to address it. And when thinking about your will, you want to consider, how do I want to divide everything up? And are any of the people that I want to leave things to, will my doing so cause a problem? Do they have an impairment, a disability, or a vulnerability that will create problems if I leave assets to them directly? And if that's the case, then you might want to consider using a trust. So let's go to the next slide. Oh, did we not have a separate trust? Can you check the next slide, Nori? There we go. So trusts are another kind of legal document that people use for a lot of different reasons. Trusts are a legal entity. You know, people, you might be familiar with a corporation or a partnership. It's another kind of entity that can hold property. There are many, many ways that people use trusts. I would start with, not everyone needs a trust. You know, there are lots of lawyers providing seminars. You might have a friend or a neighbor who has a trust and they tell you that you should have a trust. Not everyone needs one, but they can be helpful in a variety of situations. So that might be avoiding probate, which is the court process after you die of how your assets get to, you get access to assets. They might be a tax planning reason. You might have a beneficiary who you want to leave things to, who, as I just mentioned, it's going to be a problem if they inherit assets. Maybe they have a substance abuse issue, or maybe they have some other disability, or maybe they have creditor problems. Whatever it is, you might feel strongly if they all of a sudden received money or property, they will, that's going to cause them a problem. By leaving it in a trust, you can control who is in charge of that money for this person and describe the rules of how that money should be utilized on their behalf so that it remains available. There are both revocable and irrevocable trusts. Revocable means you can change it. Irrevocable means you can't. This is really something, there's so much complexity with trusts. You really want, this is a document where you really need to have a conversation with an attorney. And, you know, often I'll get a call, I want to have a trust. I need a trust. And my first thought is, well, let's take a step back and think about, what are you trying to accomplish? What are you worried about? And then let's think about, well, is a trust a document that can help you address that concern? Maybe yes, maybe no. But so don't assume that you need one. It's more, you know, thinking about what your goals are, concerns, and then figuring out with a good attorney what documents are appropriate to help you answer those, address those issues. Another thing with if you are using a trust, is thinking about who would be an appropriate trustee. This is the person who's in charge of the money. Often that can be family. You could be your trustee of your own trust. And then after you die, it may be someone else in the family who can serve. But there can be situations that arise where you might want an independent professional trustee. And there are people, you know, there are lawyers and accountants and financial institutions who can do this for you if and when appropriate.
Steve, this is such important information. I have about 4 questions in the Zoom, so I want to make sure that there's time for those. You have only about 2 more minutes because it's amazing how quick Zoom goes. Do you have other high-level points that you want to make through your slides, and then we could go right to questions?
Let's get to the, let's go through, let's just scroll through it. I think that we've covered pretty much everything I wanted to highlight. So can you turn to go to the next slide? I think we can skip this. I think we can skip the financial planning. So just, I guess, in conclusion, just quickly, the things I want to make sure you take away from tonight are the importance of communicating with your family and friends about who is in what role and how you want your decisions to be made on your behalf. Get organized. So make sure that you have all your information together. You've identified your team members, shared contact information, and the people who you're putting into these roles have that information. Update your financial and legal paperwork so that the people who you've named are still available and all the information is relevant. And when you're taking these actions or thinking about it, follow through. It's very easy to get started and not actually sign the documents because you can't make the final decisions. You know, it's the goal. We all, you want this all to be perfect, but don't let perfect get in the way of something that's good. So
Great.
just make sure you follow through and get it done. So why don't we leave that there and we can take some questions.
All right, so I'm going to read the questions that are in the chat box, and if there are about 4 or 5 of these, if you give just quick answers, that would be great, and we'll get through all of them. Can you comment on the process of affirming healthcare proxy? When is it appropriate to use, and how does it compare to pursuing guardianship?
So I'm not positive of what the question is, but if in terms of, there's one thing that's invoking the healthcare proxy. So that is, for it to become effective, your physician in writing has to say that it's effective. Sometimes in our healthcare proxy statute in the case law, if the person, even if the proxy's been invoked, if the person is refusing treatment or objecting to the treatment, that is considered a revocation or a partial revocation of the proxy. So if the person does not want to take the medication or is refusing to be hospitalized, that's taken as a revocation. And then at that point, the person who's been named has 2 choices. Either, well, they have to go to court. That's the overall thing. And then in court, they either can seek to have the proxy affirmed, basically having a judge rule that the person lacks capacity to make the decision, or seek guardianship. And though both court processes, the person who has an impairment is provided with due process. They may be counsel is going to be appointed on their behalf. So the decision could be made at the time as to which is the better choice, and that's really something a lawyer would help you with.
That's great. The next one is there a form you can fill out for appointing a durable power of attorney, or is this something you have to obtain through an attorney's office?
A great question. We get that a lot. There's nothing, magical about a power of attorney or a healthcare proxy that you need an attorney to create these documents, especially with a healthcare proxy. There's a great state form, and you can download that. It just needs 2 independent witnesses. You don't need a lawyer. If I, as a self-interested lawyer, I think it's helpful sometimes to talk these documents through with a lawyer, and the value is in the conversation you have together, so you're making good decisions. But I certainly recognize not everyone is in a position that they can afford a lawyer. And so when you can't, there are other means, whether that is getting something online. So there are online products like LegalZoom, which there's still a charge, but it would be less than a lawyer. Or you can even go to a place like Staples and buy a form. And if the decision is having no power of attorney versus a basic power of attorney without a lawyer, you want to at least have the basic document.
All right. Is a durable power of attorney responsible for outstanding credit card balances?
That's another. Everyone's asking really good questions tonight. I'm impressed. So I think if the person is asking, will I be personally liable for the debts or obligations of the person I'm serving, the answer is no. However, it's always important, and I don't think I said this, when you are signing your name, if you're serving as power of attorney and you're signing a document, you want to be very clear you're signing as power of attorney and not individually. So if I was power of attorney for Barbara, there are a number of ways to do it, but I might sign it Steven Cohen, power of attorney for Barbara. I wouldn't just sign it Steven Cohen, because then I might be individually liable. But otherwise, you don't have any individual liability if you sign your name properly, and, in general, you are making reasonable choices. So if you steal money, you're going to be in trouble. If you make a terrible, terrible financial decision, you put it all in your brother-in-law's new dry cleaning business, that's not a good idea.
Here's another one. Is there a workaround for a healthcare proxy form, which we know requires 2 witnesses? I certainly don't want to recommend that anyone who is ill go out and find 2 witnesses right now.
So we're hoping that the governor will issue an order in the coming week or 2 that would allow you to use video, like we are right now, to witness and notarize documents.
Great.
So that's one possible solution. The other is you could, and we've done this in my office, but I don't see why you couldn't do this with a couple of friends. You could drive someplace, a parking lot, and have your witnesses drive and park on either side of you, and they could watch you sign the document, and then you could leave it someplace for them to sign that they witnessed you. So you sometimes have to be creative, but I think there are workarounds that would allow, even if you were 10 feet apart, you could approach a table, sign it,
Yep.
back away, and then the witness could approach it. So there are a number of ways, if you think about it, there are a number of ways to get this done without violating, the social distancing rules we're trying to stick to.
Okay, excellent. Does Massachusetts recognize ladybird deeds?
So a ladybird deed, we don't call it that in Massachusetts, but my memory is that a ladybird deed is what we call a life estate deed. It's a little bit off subject, but a life estate deed is a deed where I want to give my house to my friend Nori, or sell it to her for that matter, but usually you would give it to her. But in the deed, I retain the right to live there and use the house, and basically retain all of what you would typically think of the ways you enjoy and own a house during my life. And all Nori really would have is she would have the right to inherit the property when I died. And that's a ladybird deed. So we don't call it that, but we recognize that in Massachusetts, and it is at times used. I don't like clients to give their house away to children. Sometimes people do that to protect it, but you are exposing yourself to risk. If you give your house to your child and then you have a falling out with your child, or your child has a financial problem, you might lose your house. So rarely would want or recommend that someone deed a house outright. And at the least, you would want to retain, either calling it a ladybird deed or a life estate, the ability or the rights to own the property and live there, so no one can kick you out of your own house.
Great. Living estates and a 5-year look-back period, I guess, for Medicare, Medicaid.
So that is a reference to our Mass Health program. I'm assuming that there's nothing that I'm aware of that's called a living estates. I did just talk about a life estate, and maybe that's what they're referring to, but
Okay.
30-second, Mass Health is a program that will pay completely for nursing home care. And many people are worried about losing assets should they become sick and need nursing home care. And they want to make sure that their spouse is protected, or that their children receive an inheritance at death. And they are thinking about giving away assets so that should they become sick, those assets would be protected. with the Mass Health program, it's obviously, it's a program with financial eligibility criteria. If you have too much, you're not eligible. But importantly, when you apply, Mass Health has a rule that they look back for a 5-year period at everything you've done financially. And if you have given away any of your assets, you've disqualified yourself and your spouse. This is a program you could speak for hours about. So I would just say, if that's something you're thinking about, you really need to speak to an elder law attorney before you do anything, because it's very easy to make mistakes. And also, it's easy to get bad advice.
Great. What happens with medical decisions if a family doesn't have an advance directive in place?
So if you don't have a healthcare proxy and you don't have a living will, often, when there is agreement among family and they're presenting, my experience is that a provider is typically going to listen to a spouse or to the children, if there is no spouse, as to what the decisions are. If there's disagreement, or there's a lot of complexity, or there's a question about the capacity, you will end up in court and have to have a guardian appointed so that the healthcare provider feels comfortable that there's clarity as to who is making the decision, who has the legal authority to make that decision.
And the last question is, similarly, what happens with finances if no will or power of attorney and a family can't afford to go to court?
Well, this is really, I guess I would need some clarity, because the will only becomes effective when you die. If you don't have a will when you die, your assets will just pass according to this state intestacy statute.
Mm-hmm.
And so if you die and you have 3 children and you don't have a will, it's going to pass to the 3 children, because that's who receives the assets under the intestacy statute. On the other hand, if we're talking about, well, what happens if you don't have a power of attorney and you can't afford to go to court, then nothing happens, unfortunately. So you won't be able, no one can access, the bank is not going, if there's a bank account, for example, with $100,000, then you won't be able to access that unless you go to court. If there is no money, then typically you don't really need to worry about it, because it's typical that you only would really need a power of attorney or a conservatorship if there's an asset that is subject, you need to get control of, or a decision needs to be made. And if you don't have money, sometimes what lawyers will do is that, they'll wait to be paid until you get the court authority to access that asset, so that you can then pay the person once you have access to the bank account.
Great. And sorry, one last question. Is there a blank will draft format online that you can print and use for a will?
Probably. I would, anything if you can imagine it, I would say it's there. I would be very careful about that. I'm much more comfortable with people doing a healthcare proxy or power of attorney themselves. Wills can be more complicated. If your life is very simple in terms of your family and who you want to leave things to, and your assets are very simple, it might be fine to do it, but it really might not, and so you have to be careful. But to answer the question, yeah, it's probably out there, and you could figure it out if that's what you need to do.
All right, Barbara, thank you.
Okay, Steve, I have one last simple question, and then to our wonderful guests, I will make some announcements and we'll say good evening. So Steve, I have followed all of your advice. I have all my documents. Here's the question. If I live half of the year in Florida or New Hampshire, do my Massachusetts executed forms serve me if I need them or my family needs them out of state?
They most likely will. The problem, and as long as the execution standards are the same, and so if your power of attorney was notarized and witnessed, it should be recognized in another state. However, from a practical perspective, you may end up having problems if it's not easily recognized by healthcare providers or financial institutions. So for some of my clients who live part of the year in one place or another, we sometimes have two sets of documents. So it's something to really consider.
Okay. All
So
right.
before Barbara, just before you, not sorry to interrupt, but I want to just thank everyone, before I sign off, and it's been a pleasure. And I was going to say hello to my parents, but I already did that. I do want to wish, it's my mother-in-law's 86th birthday. I don't know if she's still on, but if she is, I wanted to wish her a very happy birthday. She is living with us, which has been fun. And yeah, thanks. I hope everyone stays safe and is well. And I look forward to, hopefully doing this in person next year. And we can all, as Barbara said, give each other an elbow bump or whatever we're doing in 2021.
And next year, we hope to have brownies and sandwiches and refreshments. Steve, I can't thank you enough. And I want to say that though we've known each other for over 20 years, and I've learned from you for each of those 20 years, tonight I'm reminded again of how important it is to review the basic knowledge and how valuable it is for me to hear you and for you to review everything. I can't thank you enough. So grateful. Our program thanks you, and I'd like to thank your mother. You raised a magnificent son. I adore him. And now to our guests. So virtual applause. So before we sign off, I'd like to let you all know that we have a spectacular program which you'll get an invitation to on Tuesday, May 21st. I'm holding up a book. I don't know if you can see it, but we are thrilled and honored to host Eugenia Zuckerman. She's the author of a book entitled Like Falling Through a Cloud, a lyrical memoir of coping with forgetfulness, confusion, and dreaded diagnosis. You may recognize her name, as Miss Zuckerman is a nationally known novelist, television commentator, and, to quote, one of the finest flutists of our time, unquote. And we will be honored that she will be offering a live webcast from her farm in upstate New York. So you'll soon receive the invitation, and we look forward to a wide circulation. So on behalf of my colleagues, Susan, Nori, Judy, and everyone else, Steve, and to all our attendees, we so sincerely wish you well, and we wish you to be safe, and see you next month. Thank you very much, everyone. Good night.